Good evening, everyone. Very glad you could all make it out tonight. I'd like to begin tonight's talk by, of course, thanking Dr. Haas and his family and everyone here at Ivy Hall and the International Institute for Culture for inviting me to come and speak to you, lovely people, about my research. It is always an honor to be here, and I will endeavor to make it very much so worth your while. Before I launch into the meat of things, as it were, though, I want to also thank someone else who could not be here tonight, Dr. Stephen Cordova. Stephen passed away a few years ago, and I know that he was well known and he was well loved by many of you. My own connection to Stephen is as dear and deep as it is to here, to Ivy Hall and the Institute. It was here that I first met Stephen in the summer of 2015. He was teaching the Latin course, and I was taking it as a prerequisite for completing my master's in history that I had been doing at the time. At the time, one twist that I had not accounted for when I signed up for the course was that when I came to stay at Ivy Hall, that I would be sharing a roof with Stephen for the duration of the program. He was, at that time, a few floors down from me, and at first, to be perfectly honest, I was not too keen on the idea of cohabitating with the professor on whom my academic future would be dependent on. I was, shall we say, less than enthusiastic that Stephen was going to be able to witness at times how little I was actually studying, or how much I procrastinated, or that what I might try to pass off as busy weekends were actually me ordering Overbrook pizza and binge-watching Game of Thrones. But Stephen came for me to be more than just an instructor of the course. He was a mentor, and he was a dear friend. Through Latin, we discovered our shared passions and passages for history, art, theology, and philosophy. I recall our days in that summer of 2015 very fondly. We spent many afternoons in the Ivy Hall Library, just up the stairs over there, debating the immortal questions of man. Some of those questions were profound: Dante, the nature of the Trinity, Augustine's Confessions, Athens or Jerusalem, the Gospel of Q. Some were less profound, but nevertheless somehow all the more heated: Sheets or Wawa for their hoagies. Stephen possessed that rarest of all skills that teachers can possess. He was genuinely able to make the material engaging. Latin was not just a dull series of conjugations for him, but he was able to make the text leap off the page. What for many other instructors would have been a very dull expose in conjugations and Latin grammar, Stephen was able to transform the text into a thrilling story of ancient Rome, of clashing swords and death and heroism and the myths of yore. And that passion that Stephen had has always stuck with me. His passion for life, for love, and for God. It was infectious. For many people, the past is a foreign country. It is a literal dead place. Baron de Montesquieu, he described the past as a dark, cold stone maze that one could get lost in. For Stephen, it was home. In a very real sense, it was where he came from, where his values came from. When Stephen talked about Dante, he spoke about Trecento, Florence like it was his own backyard. He knew every street like it was the back of his hand. For Stephen, the past was not a foreign place. It was a treasure chest full of wonders and tools that one could study and wield against the trials and tribulations of modern life. And that's what I am here to speak to you about today, that the past is full of people and events that aren't that different from ourselves, people who suffered and the same as us, and from whose experiences we can learn that others have gone through and triumphed over the same ills that their societies face that we face. The issue of rights and privileges, of the power of the state and government, and what one could do and what one couldn't do in one's own life is one of the fundamental issues that has plagued society since its beginning. That leads me, of course, to Thomas More, who in no small part was I introduced to through Stephen. In our Latin classes, once I had revealed to Stephen my intent to become a lawyer in the future, he insisted, "You must read Thomas More in Latin then." More was the greatest of all Catholic lawyers in his mind, if not the greatest lawyer of all time, as he is to many. And Stephen insisted that More's mastery of Latin was key to that. Sir Thomas More, he was a preeminent figure of the English Renaissance. Many of you may already know him. Some of you may know him as a saint. Some of you may know him as a criminal. Some of you may not know him at all, and I'd like to change that, because love him or hate him, Thomas More is a very historically significant individual to the world that we live in, to the governments that we live under, and to the laws that we abide by or do not abide by. As G.K. Chesterton once said a century ago, "Blessed Thomas More is more important at this moment than at any moment since his death, even perhaps the great moment of his dying, but he is not quite so important as he will be in about 100 years' time. He may come to be counted as the greatest Englishman, or at least the greatest historical character in English history, for he was above all things historic. He represented at once a type, a turning point, and an ultimate destiny. If there had not happened to be that particular man at that particular moment, the whole of history would have been different." And indeed, More was many things to many people. Robert Whittington, his contemporary, called him a man for all seasons. I'm sure you've heard the phrase before. More was a writer, a statesman, a politician, an academic, a lawyer, and a judge, a theologian, and a philosopher. He is, in the truest sense of the word, what we would call today a Renaissance man. His greatest strength, though, was that he was a kind man. His friend, the great philosopher Erasmus of Rotterdam, said in 1500 that More was a man born and designed for friendship. One is more open-hearted in making friends or more tenacious in keeping them than him. However, despite More's preeminence in so many fields and the service that More did to the realm, he was condemned to die a traitor's death in the end. His crime was that he would not swear a new oath that acknowledged the king as head of the church. More contended that although the law was written and justly passed, and thus legal in a broad sense, for him it violated a higher law that existed, a deeper law that existed, and it encroached upon a more intimate, natural set of laws and rights that More refused to violate. Most significant of those rights was the violation of his own conscience. The law that More was asked to accede to wasn't just one that would force him to do or not to do something, like so many laws do, but as you'll see, it was the king and thus the state attempting to make him believe something that he did not, thus crossing a barrier and violating a deeper right, the right to the conscience. This, of course, leads me to a broader question. What are rights? In human rights law today, the way that we practice it, rights have come to mean all manners of things. People talk about rights like the freedom of speech, religion, the right to life that are found in the American Constitution and the world over. Those are considered by many to be classical rights that harken back to antiquity. Then, in the 1940s, with Franklin Delano Roosevelt, we started to talk about human rights to commodities like housing and healthcare. And now we talk about all manner of things being fundamental rights. In some jurisdictions, access to high-speed internet and Wi-Fi is even considered a fundamental right. That's all I have to say on that. However, despite this ever-broadening definition, when we talk about those oldest of rights, the ones that are enshrined in the Magna Carta and the American Constitution, we talk about what are known as liberties. They are freedoms from state action, freedom of speech, movement, right to life, and of course religion, as I've said. That is the belief and the right in the purest sense to make and decide our own thoughts, decisions, and destinies. One of the main things that I want to leave you with tonight in talking about More is a broader sense of how we think about our rights and where they come from, and the role that government is supposed to play in how we interact with them. I believe that is the story that is illustrated in the case of Thomas More. Now, for some people, even in Thomas More's time, they believed that their rights came from the government. That is where they believed that their rights originated in the most fundamental sense. If the government says that they have a right, they do, and if it doesn't, they don't. In some schools of thought, this is called positivism. Law is the will of the sovereign, the government. Laws don't exist, in their opinion, because they are moral or just, but because the government made them. This was a view expressed by many prominent legal philosophers of the 18th and 19th centuries, like Thomas Hobbes and Jeremy Bentham. To say the least with some positivists, the idea that rights could exist beyond government was laughable. Jeremy Bentham said himself in the 18th century that an idea of natural rights, rights beyond the state, was nonsense. Indeed, nonsense on stilts was how he put it. Those that oppose this view, people like Thomas More, they are often called naturalists. They believe that the law should be based on morality and not just on governmental prescribement. Even more importantly, though, they believe that their rights and the origin of their rights specifically come from a higher and deeper place. I use those words specifically, higher and deeper, because it notes both their origin and their content. Their origin is higher in the sense that, for some, those rights come from a higher order, be it from God or the natural order of the universe. For many, it leads to them being called natural rights, rights that we possess by the very nature of being human. Key to this understanding of rights is the idea that these rights are so fundamental and so inextricable and significant to our intrinsic dignity as human beings that they are and should be entirely untouchable by government to be changed or transgressed, that they are, in the most literal sense, beyond the reach of secular earthly governments. In a very real sense, they both originate but also exist in a transcendental space. For many, this is a belief that if man is created by God, then the rights originate with God too. This view of the law asserts a clear distinction between the laws and rights that the government does and does not have control over. This is often rooted in the biblical passage of Mark. Render unto Caesar the things that are Caesar's, and to God the things that are God's. As it pertains to human rights, it means that there are those rights that the state can rule upon, and those things that only God or a higher power can rule upon. It places certain rights into that transcendental space that I've talked about as so significant that they cannot be abridged, abrogated, or changed by the state's power. It's important to keep in mind that many of More's contemporaries in this sense had this view of natural law. Indeed, it is an idea that is embedded into the very idea of the common law legal tradition itself, the same legal tradition that England, the United States, and Canada share. It's the idea that the law does not derive its authority, moral or otherwise, from the state, but from history and convention. And it is a tradition that establishes norms and truths to which even the state is subject to. Under this view, it's important to remember that it conceives of government's role as declaring and clarifying law, rather than making it. In the views of the Founding Fathers and Thomas More, going back to St. Thomas Aquinas and St. Augustine, it roots itself in the idea that the rights originate from God and are secured on behalf of government, not made by the government. Accordingly, More's legal struggle is thus something that is at the very heart of the debate that surrounds human rights law. More believed that the king and government were ruling on something that they did not have the authority to, and which More's conscience could not give consent to. More believed that for man, there existed an objective law of nature that governed over a created order. This objective law of nature was inscribed onto the human heart and conscience, and it provided its metaphysical foundation and its ultimate binding force as a law. For More, it was key that the law arose from the very structure of one's being, not merely being the result of threatened punishment by the state. For if we are good, and only good because we fear punishment, it is not the same as if we only do good for fear of being bad. Now, beyond More's moral and philosophical worldview, I think that it bears saying something about his career and how he arrived at his fateful end. More began his academic studies in Oxford in 1492, and he received a classical education, becoming proficient in both Latin and Greek. Leaving Oxford after only 2 years at his father's insistence, More began legal training in London at New Inn, one of the inns of Chancery at the time, and later at Lincoln's Inn, one of the most esteemed inns of court, where he remained until 1502, when he was called to the bar as a barrister. Amongst academic circles, More could speak and banter in Latin with the same facility as he did in English. He wrote and he translated poetry, and he authored many philosophical works like his famed Utopia, a meditation on the nature of government. Faith, however, was always at the forefront of More's life, and his friend Erasmus marked that More had even seriously contemplated abandoning his legal career to become a monk. More, however, opted for a lay life, continuing his legal studies and standing for a seat in Parliament, first in Yarmouth, and then in London, and then marrying in 1505. As a judge, More famously ruled even-handedly, regardless of the person who came before him's station. From the highest-ranking officials that came before him and nobles in the elite court of the Star Chamber to the lowliest figures in pure men's cases, More was noted not just for his belief in equality under the law, which in itself is a fundamental right that we often take for granted today, but also for his habit to ask the accused before rendering judgment why judgment should not be given against them. It was a simple act, and for some probably considered superfluous. More in this respect, he also quintessentially encapsulated the most valued traits that judges can possess. By letting the accused speak before rendering judgment, it always showed that the judicial mind must never be closed. It evoked the idea that until the last moment of the trial, something could change, and that the court was open to hearing it when deciding someone's fate. This was key to More's belief that the court system and the law wasn't just about punishment. It was also about aiding people, about justice. As will be seen, this is in stark contrast, of course, to the court that convicts More, where judgment was already passed before the trial had even been convened. More ascended in 1529 to become the Lord Chancellor of England. It was the highest office in the realm at the time, responsible for equity and common law, overseeing everything from contracts and royal household cases and misdemeanor appeals. It was the supreme authority in matters of legal appeals, and perhaps ironically, it also included, as one of its responsibilities, the role as keeper of the king's conscience, a duty of the office that More was perhaps too successful in, which cost him his life. As Lord Chancellor, More was known for being able to dispatch cases with unprecedented rapidity. For his great many skills and sage counsel, More had become one of King Henry VIII's closest advisors and one of his best friends and confidants. Now, as I'm sure many of you know, the reign of King Henry VIII of England was a rather turbulent one. In addition to his problems of foreign wars in France and Italy and mounting debts for the realm, his reign was beset by a pending succession crisis and religious upheavals, the two quite closely linked, as you will see. For Henry, when he was king, he had no male heir from his first wife, Catherine of Aragon. This led to a large series of problems in the kingdom that saw Henry's multitude of attempts to get his marriage to Catherine annulled and set aside so that he could take a new wife, Anne Boleyn. As part of this, being a religious matter in the nature of marriage, Henry sought from many of his highest legal and religious advisors to find a legal precedent and avenues to have the marriage set aside. Henry tried all manner of legal strategies, from trying to claim infidelity to trying to rely on biblical law in Leviticus and more. The matter, however, disquieted Thomas More. The king was not just asking what was the legal thing to do, or what he could do under the law. Instead, Henry was trying to use the law as a pretense for what he really wanted to do. Henry had repeatedly attempted to claim that Catherine had been unfaithful to him, and this was grounds for the annulment, and that Henry had broken divine law by taking his deceased brother's wife to wed. But More simply could not agree with the king in this regard. For More, Henry had made the issue a fig leaf, a veneer of legitimacy across his actions. This was the antithesis of More's own philosophy, for whom the law was an ultimate and unchangeable guiding path for his worldview. Ultimately, though, Henry failed to secure papal approval to annul his marriage to Catherine, and the Pope simply wouldn't sanction it. This, of course, led to tension between More and the king. More's refusal to accept Henry's claim that his marriage to Catherine had been illicit meant that he was demonstrably in opposition to the king. This was the beginning of More's downfall. More resigned as Lord Chancellor soon after in May of 1532, and the king ultimately decided that if the Pope and the Church could not give him what he wanted, he, as head of his own church in England, would achieve it. This ultimately led to England's break with Rome in the Reformation and a sharp break between papal authority in Christendom and England. Accordingly, Henry passed laws that declared himself the head of the church and required everyone to swear an oath of succession, recognizing his religious authority and renouncing the Pope. For Thomas More, though, the issue went beyond just personal religious beliefs. For him, the law was a sacred instrument that bound society together and made it just. And with the oath of succession that he was going to be asked to take and the break with Rome, it was the king using the law not just for the good of the realm, but for his own personal means, extending the power of the king to unnatural ends. Now, it's important in this respect to remember that More was not the first person to have disputed the authority of the king and the crown and the royal authority and prerogative in this manner. In a very real sense, the struggle of the authority of the rights of the people versus the authority of the crown was something that has been the most omnipresent issue in English legal history. Magna Carta, in the reign of King John, perhaps the most famous common law legal document that was ever written, was designed to check the power of the king over the rights of the commons. Thus, when we talk about More and the significance of his trial, it's not one that had at its core some obscure issue of legal precedent or technicality, but it was something that dealt with the heart and soul of the common law legal order, the power of government and what it can or cannot do, something that we still struggle with today. More shows us that if we allow the laws of our society that make our society to be distorted by our leaders for personal goals, then they aren't really laws at all. They are scraps of paper to obscure the tyranny that we really live in. In More's view, there was a realization of what he had considered for a long time to be his greatest fear, a government and the crown that viewed itself as able to transcend and transgress the idea of rights. In that regard, More encapsulated the idea that, as he said, if the lion knew its own strength, it was hard for any man to rule him. Now, the king's new act and the corresponding oath that it required everyone to take was ultimately unpalatable for More and unconscionable. The oath of succession, in effect, mandated that all ecclesiastical law required royal consent, something More disagreed with and that he refused to swear to. For this, More was arrested in April of 1534 and held at the Tower of London. While there, Thomas Cromwell and others repeatedly sought to secure his support for the language used in the Acts of Supremacy and Succession, which mandated the oath. More remained silent. Up to 4 attempts were made to have him swear the oath of succession, but More was adamant that he would not. In any other time, More's strategy of silence would have worked, but for Henry to have the elocution of acknowledging his supreme authority over the Pope was the point. The situation was worsened, however, when Parliament also passed an additional Treason Act in 1534, and it was this that was used to condemn More. Under the terms of the Treason Act, one section that scholars have noted was specifically in direct response to More and his silence, stated that anyone who did not recite the oath deprived the king or queen of their legal heirs of the dignity, title, or name of their royal estates, and was thus a traitor. Almost humorously, More had such a great knowledge of the laws of the time that Parliament had to pass a new law to charge him with, as he had mastery of all those that already existed. Silence in this instance was seen as overtly denying the king and his title of supreme head of the Church of England, and that was treason. Now, before More's trial, he was summoned before the court at Lambeth Palace. He requested to see the text of both the oaths and the Act of Succession. More told the commissioners that while he denied nothing that was contained in the oath, his conscience would not allow him to take it. Again, they demanded that he take the oath. They cajoled him, they threatened him, they implored him to take the oath. More refused again and again and refused to elaborate. Frustrated, the commissioners turned More over to the Abbot of Westminster and then to the Tower of London, and after spending a year in the Tower, More was finally tried for treason. More was brought to trial on the 1st July of 1535, and the outcome in the minds of many was never seriously in doubt. In those days, treason trials were often a foregone conclusion, for to find someone innocent of treason was also considered treason itself in a lot of cases. More attempted to answer every charge that was brought before him in court. He freely admitted that he had opposed the annulment of King Henry's marriage. He said that according to the dictates of his conscience, he had told the king of his true opinion. More contended that he had given the king an honest answer, and when asked for it, and that to be honest was not treason. On not swearing to recognize the king as the supreme head of the church, More said that no law in the world can punish any man for his silence. When told that his silence was an evident sign of the malice in his heart, More quoted a legal maxim and held that he who holds his peace gives consent. More rebutted the court's every point. He was a lawyer to the very end. But he did not conclude his rebuttals by placing his final argument solely in his belief that the new laws violated the laws of the church or God. On the contrary, More rooted his argument in the fact that such laws violated the English Constitution itself, the Magna Carta, and the king's own coronation oath. What is the most remarkable about More at his trial is that he did not hope for divine intervention or for a last-minute change of heart from the king. Instead, More placed his ultimate faith in the law and the law alone, and his knowledge of it and ability to practice it, steadfastly believing that it was the law, the true law, that was on his side, and that he would be able to use it to save himself and his family. In response, however, to More's weighty arguments, the Lord Chancellor, that was presiding over the trial, pressed More on how he reconciled his opinion with the fact that supposedly all the bishops from every university and even the most learned men in the kingdom had found the act lawful. More responded that he didn't care. And that's where we get to the root of it. More's display of conscience rights is found in his belief that even though the law is passed, even though all of the other lawyers, all of the other judges, all of the other academics, all of the other philosophers accept the law, he does not because he knows that it is wrong. That consensus does not make lawfulness or justice. More remarked that this law was a two-edged sword, for in consenting to it I should endanger my soul, and in rejecting it should lose my life. And with that, More was sentenced to death. And this, I think, is where we come to the crux of the matter of More's dilemma, which is that how it relates to our own conscience rights. What is the state able to make us do and to tell our consciences not to do? What do we do when our own sense of right and wrong and morals come into conflict with what the state dictates and what the state says is wrong or right? Keeping in mind, beyond just a religious sense, More placed the law above the king, and in his regard, he was legally correct. Even the king is supposed to be responsible to the law. But what do we make of More's decision at the end and his legacy? Was More acting for his conscience, something he did for conceit for himself, or for a higher and nobler purpose? I know that Robert Bork, former American Solicitor General and judge for the U.S. Circuit Court of Appeals in D.C., he had conceived of More's act as almost like a form of civil disobedience. In this regard, Bork, he quoted the legal theorist Alexander Bickel when he described civil disobedience, saying that no matter by whom or in what cause, such a disobedience was always a decision in favor of self, in favor of the idea of self. Now, while I don't think that he was entirely wrong in his conception of More's actions, I think that that framing from a historical and a legal sense is somewhat limiting. More conceived of what he did not just as an action for his own conscience, but also he was opposing the tyrannical usage of the law, and thus by definition something bigger and more transcendental than himself. And it's because of that, and More's refusal to take Henry's oath, that it's not an act of civil disobedience in the traditional sense, but rather an act of obedience to truth, and thus in a genuine sense, an act of genuine liberty. It frees in that sense. But I also think that it has to do with compulsion. At the core of it, compulsion is the opposite of liberty. And with civil disobedience, Bork used the example of conscientious objectors and draft dodgers to illustrate his point about More. And that is the state attempting to compel what one can do, in that case to kill for a cause that one deems unjust. In More's case, though, and this is where I will differ from Bork again, the abrogation of rights is not what one is made to do when one is made to believe, like in the case of Thomas More. It's an even deeper form of compulsion, in that it seeks to compel one's heart and soul. More's sense of conscience rights protects an even deeper element of how we conceive of the self, not just in what we can do, the way a draft dodger opposes war, but what we believe to be right and wrong, just and unjust. This is part of the broader issue of where we have to ask ourselves where rights come from, as I alluded to at the beginning. If our rights come from government, and they are enshrined in the laws in the government, shows itself as willing to warp and distort those same laws towards its own ends, then perhaps government is not the best place to find rights. Instead, as Thomas More and many others like him thought, rights come from an altogether different realm. They were, in a very genuine sense, transcendental. Whether or not one believes they come from God, the essential element to that view of natural law was that the rights originated and existed in a higher plane, that the state cannot and should not touch them. More's legacy ultimately is one for us to consider in light of a lot of our current issues on state authority and the power of the government's ability to make laws, but also to take laws away, to take rights away. Fundamental in this sense to More's philosophy in his own writings, and particularly in his own work, Utopia, was the acknowledgement that we, in a very real sense, should not try and think of a perfect society with perfect laws because we will never achieve it. Instead, More suggested that those who find themselves as future statesmen should not only do the best that they can with the form of government that they receive from their predecessors, but they should also work to conceive of a better and a more just society. It's rare that we have the power ourselves to actually achieve it, More noted. Instead, More suggested that what we must do is to make decisions that are within that system, that are within our own power to change, and that are just and that satisfy our own consciences. As More himself said, "Don't give up the ship in a storm because you cannot direct the winds. What you cannot turn to good, you make as little bad as you can." Thank you.